The next session by MCIA is on the next edition of the MCIA Rules, Key Features. On the panel, we have Ms. Shaneen Parikh, MCIA Council Member and Partner and Head International Arbitration, Cyril Amachand Mangaldas, moderating the panel. We have Andrew Pullen, Barrister at Fountain Court Chambers, Christoph Kauffmann, Counsel at Osborne Clark, Fatema Kachwalla, Partner at JSA Advocates and Solicitors, Mr. Vikram Nankani, MCI Council Member and Senior Advocate, and Mr. Ranjit Shetty, Senior Partner at Argus Partners.
Is this on? Yes. Well, hi everyone, and those who are not grabbing a cup of coffee, come and sit down. Welcome to the last session of the day. They say the best is saved for last. I like to think so. Or maybe it's just that we're loath to let you go. Either way, we're going to try and make sure that this session is worth your time. Today's panel will discuss the key features of the proposed revisions to the MCIA rules. As a member of the MCIA Council and the Rules Revision Committee, I'm delighted to be able to moderate this panel. Work on the revision started almost 2 years ago and have gone through several iterations and heated discussions. But as MCIA hits its 100th plus case, they are ripe now for public consultation, and we're looking to hear from all of you, the actual users and stakeholders in the arbitration process. MCI was founded in 2016 and is now in its 8th year. And during this time, I can think of at least 5 developments that have led us to this point. Number 1, India's Arbitration Act was amended twice, in 2018 and 21. Institutional arbitration has become the norm with private parties, and there is a concerted move from the government to adopt institutional mechanism even in government contracts. And no, I'm not going to answer any questions about the June 3 circular. Please reserve those comments for another day. Thirdly, our legal infrastructure has undergone considerable sophistication. For instance, with transcription and terrors that you see today being available in courts, as also regular online hearings. And arbitral institutions across the Asia-Pacific region have also elected to revise and relook at their arbitration rules. Though most institutions wait a decade or so before even considering a revision, given the progress of India as a whole, not just in terms of ADR, but also in terms of the business and the regulatory regime, we felt the time was right for MCIA to double down on its efforts to be a truly robust, reliable, and independent arbitral institution. Having a council with expert arbitration practitioners, both counsel and retired judges from several jurisdictions, means that we were able to look at, consider best practices and consider tweaking the rules using both hindsight and foresight. We also have to keep in mind the unique position you have in arbitration in India, which is almost a dual regime, and it differs quite substantially from the way international arbitration is conducted. That said, we also had to keep an eye on MCIA's ethos, which is not that it is an Indian arbitral institution. It is, and we hope it will be, a truly international institution, agnostic of its place of incorporation. The experts on our panel, who include council members and other users of the rules, will keep you riveted, I hope, as we discuss some of the headline changes proposed. And I'm looking forward to their rules so that they may inform some further revisions. So I'm going to start off with Rule 6 on consolidation and start with Ranjit. Now, the current rules already contain provisions for consolidation. What is different in the new draft, and how is it better? Is it better?
Well, it's definitely better. I don't think that needs a lot of discussion. When we discuss the rules, it will become evident. The proposed amendments actually capture what is expected from a arbitral institute of MCI standards and is at par with the rules which other institutions also offer. Do we have, we are not having the rules on the screen, right? Shine?
No.
No, we are not, right? No problem. So then I'll just go through this, don't worry. So, some rules which I think is of relevance and which shows how MCI has approached this. The rule 5.1, which is existing today, allows consolidation of two or more arbitration proceedings, which provided that all the parties agree to the consolidation, or all claims in the arbitration are made under the same arbitration agreement. Well, the proposed amendment now widens the scope of MCA to consolidate. It says, it talks of a concept of arbitration agreements being compatible, and the rule reads as thus. It says that the arbitration agreements are compatible and at least one of the conditions are met. Disputes arise of the same legal relationship, disputes arising of contracts comprising of a principal contract and ancillary contracts, or disputes arise of the same transaction of a series of transactions. Now, it's obvious that the addition of this sub-rule C substantially widens the scope of MCI Council. This will also allow parties to consider consolidation for a larger category of arbitrations. The benefits of consolidation remain the same. It's saving on time, cost, and of course, inconsistent arbitral awards. Some of the examples for consolidation, which everyone should know, is shareholders' disputes, principal contracts, executed by parent companies and subsidiary companies. It could also be useful for related party transactions. Another interesting rule is 6.12, but the rule as it reads today is Rule 5, that only MCI Council is empowered to order consolidation. Now, under the proposed amendments, MCI still has the power. However, after a tribunal is appointed under Rule 6.12, a party has to approach the tribunal for consolidation of all or any of the arbitrations. Now, the tribunal will factor obviously the following, that one is all parties agree to the consolidation, all claims are under the same agreement, same tribunal is appointed, and three is that the arbitration agreements are compatible. Now, under compatibility, just to recapture what we discussed earlier, three categories were there initially. The disputes arise out of the same legal relationship, disputes arising out of contracts comprising of principal contract and ancillary contracts, disputes arise out of the same transaction or series of transactions. Now, this is the fourth one. When it comes to a tribunal, the tribunal can also has this to consider: a common question of law or fact arises, a common question of law or fact arising out of or in connection with all the arbitrations. Now, this is something in addition which the tribunal can consider. Again, the proposed amendment seeks to permit parties to make a request for consolidation even after the appointment of a tribunal. Just to give you an example, there could be an arbitration which is ongoing between two parties, and the claim made is for monies which are otherwise due. Whilst that arbitration is going on, one of the parties has terminated the agreement. And this is an example where both the parties can agree for consolidation of the arbitration. Rule 6.15 is important. It has the power to revoke appointments already made. Now, this is important because some other institutions cannot consolidate different arbitrations after a tribunal is formed because the institutions do not have the power to revoke earlier appointments. Now, MCA has done this. The proposed amendments gives it that power. Rule 6.9, 6.14, and 6.16. This talks of the decision of council or the tribunal to consolidate proceedings, and it says that the same is without prejudice to the tribunal's power to decide on its own jurisdiction. Thus, a party can challenge the jurisdiction of a tribunal is not barred or precluded on the ground of MCI's decision of consolidation. Just to repeat, just because you agree to a consolidation doesn't mean that you cannot challenge the constitution or the jurisdiction. That said, a party who has otherwise not had an opportunity or otherwise did not participate in the constitution of the tribunal or consolidation of proceedings shall be deemed to have waived his rights under proposed rule 6.19. But this party is not barred from challenging the tribunal's jurisdiction. 2 points which are worth discussion, not necessarily of a concern, is that Rule 6.2 and 6.12, a reading of these rules, it appears that the consent of all parties are not necessary or not mandatory for consolidation of proceedings. Now, in a case where a request for consolidation is made on fulfillment of conditions which are other than a consent, in a challenge to an award, there is always a potential risk of a court adjudicating on whether the consolidation was appropriate. This is some aspect which I couldn't find any judicial precedence, and I think since it's an amendment, this is something that will need to be seen as the law develops. Now, interestingly, on this very aspect, the amendment to the rules, which is proposed rule 6.7, the MCA Council may grant or deny an order of consolidation without having to furnish reasons in support of a decision. This proposed amendment, in my view, can have some consequences, and the award could be vulnerable to a challenge. This especially when the party's consent is not a mandatory precondition under the proposed rules. So this is my bit on the proposed amendments. Shane.
Thanks, Ranjit. So, Andy, I'm going to ask you a question on a different rule, but before that, I wanted your thoughts quickly on the difference in the evaluation process between consolidation, where an application is made to a council, to the council, or to the tribunal.
Sure. So just a couple of quick points on that. I think it's interesting that the MCIA have made this change. So now once the tribunal, or once a tribunal is appointed in any of the arbitrations that are subject to the consolidation application, it's the tribunal that decides that. And it's interesting, if you do an international comparison, some rules reserve the power of consolidation to the institution. The ICC and the HKIAC do that. SIAC does it the same way that the MCIA is proposing to do. And I think that is probably sensible, actually, the way that the MCIA is doing it, because the tribunal will, by this point, know more about the dispute in many cases than the institution will itself. And I think that flows on into the second point that I had to make about this, which Ranjit mentioned, the fact that there is an additional ground, which is a common question of law or fact, arises in both of the proceedings. That's an additional ground for consolidation where you've got compatible arbitration agreements, and I think that is a sensible thing to add in. I think in many cases it's not going to add a great deal, but it seems to me that it is useful to include it. And my observation is that at first it may seem anomalous that that's a ground for the tribunal, but not a ground for the council in a pre-tribunal, in a pre-constitution of tribunal situation. But again, perhaps that's explicable by the fact that judging whether there's a common issue of fact or law is going to be easier for the tribunal than for the institution. The other sort of grounds, same legal relationship, principal and ancillary contract, same transaction, those are a little bit more mechanistic and easy to judge for the institution, whereas common issue of fact of law, how important is that? Is that really something that deserves consolidation of the two proceedings? That is going to be something which a tribunal is probably going to be better placed to judge.
Thanks, Andy. I'm going to come to Rule 7 now, which is concurrent proceedings.
Yeah.
Now, this is a new rule. It seems to track some proposed revisions that other institutional rules are considering. What is the purpose or the benefit, and what are these concurrent proceedings?
So I think the thing to do is to think about concurrent proceedings and consolidation together to then think about the difference. So in a consolidation, you take two arbitrations, they are essentially merged. You then have one proceeding in which all of the parties to the previous arbitrations are now party to a single arbitration. The tribunal can make an award binding all of the relevant parties, all of the evidence, all of the submissions is then in that single arbitration. Concurrent arbitrations, or concurrent proceedings, is where the arbitrations technically stay separate. They are separate arbitrations. But the way that the rule works is it allows to have concurrent proceedings where you've got the same tribunal appointed in all of the separate arbitrations. So you might have 2 or 3 separate arbitrations, same tribunal. The parties remain they may be different parties in each of the different arbitrations, founded under different arbitration agreements. So the evidence, the submissions will all be common across all of the, say, 2 or 3 arbitrations, but they technically remain separate. The tribunal will have to make separate awards in each of the different arbitrations. And it seems to me this is useful in situations where it may not be appropriate to consolidate for whatever reason. And I think this is something, just looking at the grounds. So you have to have the same tribunal, and then the grounds allow you to have concurrent proceedings where there's the same arbitration agreement is the basis for all of the arbitrations, or the arbitration agreements are compatible, the dispute arises out of similar legal relationships, which is perhaps slightly broader than the same transaction or same legal relationship that you have in the consolidation rule, or it says out of the same transaction or series of transactions, which is a similar sort of thing. I suppose my questions about this are twofold. One is, why doesn't it include the principal and ancillary contract situation? And so that is something that I think perhaps MCIA should think about, whether that should be added in as well. And the other thing is the requirement for the arbitration agreements to be compatible. And really this goes back to a case called Duro Felguero, which was a 2017 case here in India, which was about a construction project. And to cut it short, many of you I'm sure will be familiar with this, but there was essentially there was a foreign party, Duro, that had been awarded a construction project. For convenience, it was divided up into a series of different contracts, some of which had the international party, Duro, as the contracting entity. And in other cases, it was a local Indian subsidiary that was the contracting party. Now, then ended up with a series of arbitrations, one under each of the contracts, and the Supreme Court refused to order a consolidated reference because where the international party was concerned, the arbitration was international, whereas a domestic Indian counterparty, it was a domestic arbitration, and therefore, as you all know, the grounds for setting aside are slightly different. And so that seems to me a situation where they are incompatible arbitration agreements, but in the Duro case, the same tribunal was appointed. And so it does seem to me that that is a situation where concurrent proceedings could well be sensible. And so I think this is, again, a slight tweak to slightly broaden out the scope of the concurrent proceedings rule might be worth considering.
Thanks. Andy, I have just one question I wanted to ask. In concurrent proceedings, so does it mean that the evidence-led in one proceeding can be adopted and treated as evidence-led in all the others?
Exactly. So I think this would be up to the tribunal to give a detailed order as to exactly how it works. But that's the way in which you can do it. And typically a big time saving and cost saving can come from that, both on the written evidence, the submissions, and also having a concurrent hearing.
Okay, thank you. Okay, now for the audience, the good folk at MCIA have told me that you should, and please do, check out the rules at mcia.org.in. I can see 0 people having picked out their phones, which means that you obviously already have the rules with you. Okay, thank you. All right, Fatema, coming to you now.
Right.
As counsel, how would you differentiate between consolidation and concurrent hearings? We've heard from both Ranjit and Andy. And what are the different implications? When would you choose one over the other? Very quickly.
Okay. So it's been very set out in a detailed manner by Ranjit and Andy, so I'm not going to repeat it. But briefly, consolidation is where 2 arbitration proceedings are conjointed in a single arbitration. and it's joined to the one which had commenced first. So all subsequent arbitrations will join to the first one with either the consent of the parties or based on the hearing, which will not require the consent of the parties. Now, concurrent proceedings, on the other hand, is conducted parallelly by the same arbitral tribunal. It may include those proceedings where the plea for consolidation was rejected, in which case you then have the chance to go for concurrent proceedings. Now, as Andy had rightly pointed out, there are some differences between concurrent and consolidation in terms of the parameters why you will start concurrent proceedings. The advantage of both is going to be decided by the same arbitration panel. So the concurrent proceeding also sets out that the arbitration panel remains the same. So that advantage remains. The difference is whether it will be heard in a conjointed manner or differently. Now that has its advantages and disadvantages. But whether you can prefer one over the other is as good as saying that in a litigation, will you go for a writ over another remedy? You can't decide. It will be decided in the facts of the case. It
depends.
So, I mean, for example, in a shareholders dispute where all the shareholders have a common dispute against the company, I would say consolidation will bolster your evidence against the company, go for consolidation. Whereas, say in a case of an EPC contract where there are various contractors against a state-owned entity, there may be chances of counterclaim enforcement issues. In that case, you may want to control your independent proceedings where you have the advantage of a single or similar arbitration tribunal, but at the same time, you want to control your proceedings. So in that case, maybe concurrent would be better.
Very interesting. Okay, Vikram, I'm going to come to you. Now, listen attentively because I have a long question for you. So we go to Rule 8, joinder. Rule 8.1 allows a party or non-party or an additional party to be joined in an arbitration. Now, the term non-party does not feature in our Act. So, my first question is, what meaning can we ascribe to these terminologies? Are they different? But I'm not stopping there. I'm asking this question particularly in the light of the Supreme Court's decision in Cox and Kings, where the Supreme Court ruled on the group of companies doctrine and considered it useful in the context of complex multi-party, multi-agreement transactions. And Justice Chandrachud observed, the term non-signatories instead of the traditional third parties seems to be the most suitable to describe situations where consent to arbitration is expressed through means other than signature. Therefore, can non-party be likened to third party? Do you have to look at consent when you look at non-party? Do you look at the alter ego doctrine? Do you pierce the corporate veil? And really my question now is just a broad brush. How do you marry all of these together?
It's not fair that you intimidate somebody who is not a party to the panel and has been asked to join. So what you, ladies and gentlemen...
Thank you profusely to Vikram for joining last minute and taking on the toughest question.
What you, ladies and gentlemen, have just seen or experienced is how a non-party is added to a party. So that answers it all. Shaneen, can I get away with that? Probably no. You're vigorously shaking your head, saying no. Okay. I think it's more a matter of semantics once you compare it with the ratio of Cox and Kings. Whether you call it non-party, non-signatory, or third party. Essentially, if I were to use a colloquial expression, sorry, my friends who are not from India, the mool mantra of all this is that do you satisfy the test in Cox and Kings? And therefore, any discussion on these topics means that you cannot avoid discussing Cox and Kings because that's the latest judge-made law in India. And I think we are blessed with that law because at least to my limited knowledge, this is the only Supreme Court in the world which has expounded on this theory of non-signatories and third parties. So what is it that Cox and Kings says? I think it's still a mystery which people are trying to unravel. what I can discern from there are the following points. Number one, that the group of companies doctrine, which in India held the field since chloro control, which was 2012, has been largely misunderstood. And that doctrine is like the elephant being felt by the 7 blind men, you know. Whatever your experiences are, you would rope in and say, this is a necessary party or a proper party. You virtually, under the garb of group of companies doctrine, were bringing in the baggage of civil court tests of necessary and proper parties, because you were getting into various other factors which completely destroyed the corporate identity or individual entity status of different companies. So therefore, I think this has been now well explained, that there is no magic in the words group of companies. Group of companies cannot be just a simpliciter ground for adding a non-party, and henceforth this expression shall include third parties and non-signatories. So that's one clear ratio emerging from Cox and Kings, that group of companies by itself is not any test to join a non-party. The second is that you have to look at the participation, conduct of any person. It may not be a group company, it may be a rank outsider, unrelated party, and as popularly understood as a third party. If you are able to demonstrate, and that's a matter of evidence, that another party who is not party to the arbitration agreement has conducted itself in a manner that, for example, it has participated in the performance of the contract, and if you can justify that, therefore they had a implied consent to the arbitration agreement, I think then you can join a third party or a non-signatory. Which brings us to the fundamental principle of arbitration, that it is by consent. So ultimately, in Cox and Kings, what the court has held, that you look for consent in some form or some manner. It may not be express consent, it may not be in black and white, it could be by conduct, it could be by participation, and as long as you are able to drive the point that there is an implied consent of a third party being bound by the dispute resolution mechanism chosen by the signing party, then you can bring in that party in arbitration for a holistic determination of the dispute. So that is, I think, the ratio, ultimate ratio of Cox and Kings, that you look for implied consent and some of the factors that are relevant to determine whether there is an implied consent or not, as I said, is participation or conduct. So you can't lift the corporate veil, you can't get into the alter ego doctrine, which are all facets of group of company doctrine. So those old thoughts have to be given a go by. Where it gets a bit confusing, and you sometimes tend to think that there is a gray area, is because the constitutional bench has upheld the validity of Cherian properties. Now, Cherian properties was a very unique, in a sense, it's a sui generis case. Cherian property arose out of proceedings under the Companies Act, and the parties had gone to the National Company Law Tribunal for execution of the award, because the award was for transfer of shares by A to B held in a company C. C refused to transfer the shares and said that we are not going to transfer the shares in the name of the judgment holder or decree holder. And it is from there that the matter went up to the Supreme Court. And in Cherian properties, while saying that a third party will be bound by the arbitral award, what really the Supreme Court held was that in execution proceeding, a party which claims through the judgment debtor cannot avoid the consequences of the award. Now that is very, very different from the issue which they decided in Cox and Kings of a third party. This was, Cox and Kings is a stage of Section 8, which we know in India is where you refer parties to dispute, something where you avoid in an anti-arbitration injunctions that you get in elsewhere in other jurisdictions. So Section 8 is something like that. And Section 11 is the power of the courts to appoint an arbitrator. So that was the critical issue or the key issue in Cox and Kings. But by upholding Cherian Properties, which was in a completely different factual matrix and arose post-award in an execution proceeding, there is sometimes some confusion in some minds as to really, has it traveled beyond the implied consent test, the Cox and Kings judgment, or has it gone back to group of companies doctrine in a very indirect fashion? I would not think so. I think it has buried the group of companies doctrine once and for all and said it in so many words that you can't get into alter ego or pierce the corporate veil. So Cox and Kings is, I think, our rules which are proposed, Rule 8, would ultimately play a role, and depending on the governing law of the contract or the arbitration agreement, I think Rule 8 will definitely Cox and Kings will have a bearing on the interpretation of Rule 8, either by the tribunal or the council.
Thanks, Vikram. Christoph, so one of the conditions for joinder includes a party or non-party being prima facie bound by the arbitration agreement. How do you see this test playing out in practice, and can you give me a sense on how you've seen it compared to other institutional rules?
Yes, thank you. I've read Cox and Kings, and what I kept in my mind is consent as the cornerstone of arbitration, and I think that also applies to other institutions as well. And I think the MCIA did a great job to include these joinder rules. What I find really interesting is that a non-party has the right to apply for joinder. And comparing that especially, for example, to the German DIS rules, the German Arbitration Institute, that is unknown there. So, and also compared to Article 7 of the ICC rules. So a third party, and the interesting question on that, and Nisha and I discussed this beforehand, how does the party know, right? Sometimes third parties are not aware of an ongoing arbitration. And so I think it's an interesting point to include that here, and an interesting idea. I think it's a good idea, and we have a similar approach in German courts and German civil procedure, where a party which is not a party to a proceeding can ask for joinder. So yeah, I can just say that it's an increasing efficiency and flexibility. So yeah.
Thanks, Christoph. So we move on now from these multiple arbitrations and multiple contracts. Now, disputes in the last several years have almost become their own asset class, and a new breed of funders more common. And as this has increased, several institutions have also revised their rules to take into account third-party funding of a party, usually a claimant. Now, as there are different stakeholders and consequences in the process, this funding needs to be disclosed, and that is what new Rule 37 provides. So, Fatema, what are your thoughts on the rule? Is it necessary? Does the rule need to go further? How do you see it being played out?
Thank you, Shaneen. So Rule 37 deals with third-party funding, which is an emergent topic in the litigation sector. We see a rise in third-party funding agreements in litigations or arbitrations. While historically, third parties were prohibited from funding unconnected party litigations under the doctrine of maintenance or champity, but in the current era of encouraging access to justice, many jurisdictions have opened that road, including international arbitrations. Particularly international and domestic arbitration, given the nature of party autonomy and addressing commercial disputes of private parties, have naturally become a more lucrative forum for third-party funding. But we do see the trend is emerging in the international market and various other rules. However, in India, there is no such legislation as of now. Therefore, the rule is quite a welcoming rule in the Indian jurisdiction, especially in the arbitration regime. Although India lacks formal legislation, there has been a positive trend in the way courts have seen third-party funding since many years, and we'll be surprised that the first time the court had taken note of third-party funding was the Privy Council in the year 1876. That's in the case of Ram Kumar Kondu, where it said that such kind of agreements are fine, but they need to be carefully watched so that they are not unreasonable, unethical, and not against public policy. Recently, in the case of A.K. Balaji, the Supreme Court has said that while there are restrictions on lawyers funding the litigation, there are no restrictions on third-party funding them. However, the third-party funding has really gained recognition in the recent judgment of Tomorrow Sales. And it's important to analyze this judgment before we get into the rules, because really I feel that's the sequitur to the rules. So in this matter, the claimants SBS Transport Logistics Private Limited had initiated arbitration against SBS Holding. Now the claimants had availed funding from this entity called Tomorrow Sales Agency for the arbitration. The tribunal rejected the claim of the claimant and imposed costs, including penalty. The respondents filed a petition before the Delhi High Court seeking certain interim reliefs, injunction, and details of the assets, not only of the claimants, but also of the third-party funder. The single judge, interestingly, granted the reliefs in favor against the claimant and the third-party funder on the ground that the third-party funder had a vested interest in the outcome of the litigation, and therefore they will have to bear the cost. On appeal, the division bench of the Delhi High Court has reversed the single judge order on the ground that the third-party funder was not liable because under the funding agreement, the third-party funder was not under any obligation to fund an adverse order. Also, as per the funding agreement, in the event the claim was not successful, the third-party funder would not be liable to take financial recourse from the lawyers or the claimants. So it was not anyway working on the other side, so it could not have worked in the reverse. Further, the division bench said that third-party funder really is not a party to the arbitration, and therefore you cannot go against them. In this judgment, the courts laid emphasis for formal rules, including the norms for disclosure for third-party funding. Although the matter is now before the Supreme Court and there's a hearing chalked out recently, but in light of this, Rule 37 is quite a pleasant introduction in this regime, which calls upon the parties to make several disclosures during the arbitration process. One is on existence of third-party funding. Second, the identity of such a funder. I feel that is important to govern conflict of interest issues qua the arbitrator or even the lawyers. Third, whether the funder has undertaken to bear any adverse cost liability. This will assist the tribunal while deciding the cost or even the application for security of cost. So the introduction of Rule 37 is quite a welcoming move in the regime of TPF arbitrations. And especially in the light of what is going on, we've also seen in the case of Go Air, the COC of Go Air has taken third-party funding in its ongoing international arbitration, which is going on. So the trend is changing, it's emerging. Even in insolvency cases, people are going for third-party funding. So the rules are a must. It's also in sync with the proposed draft amendment. So the language or the concept of disclosure is also in sync with that. Of course, there are areas where we need to be careful, or maybe the rules can be further thought of, such as the amount of control a third-party funder may have in an arbitration, who's really going to run the process. There may even be conflict of interest between the funder, the lawyer, and the claimant. And this conflict may become more acute in case of a negotiation or settlement, because a third-party funder is really a repeat player and has different goals as opposed to the claimant, who is a one-time player and may have different goals from the outcome of the case. Similarly, enforcement issues are not really tested as of now. So these are things we need to be careful while even drafting the third-party funding contract, which will effectively govern the process, because the disclosures are from your contract and will govern the process going forward in arbitration.
Thanks, Fatema. So the rules really require disclosure by a party. Of course, the Act in the 5th and 7th schedule also requires disclosure if an arbitrator has a relationship with a funder in an arbitration. But Ranjit, do you think Rule 37 goes far enough? And do you think there should be consequences prescribed in these rules for non-disclosure?
I'm not sure whether I have a straight answer, whether there should be consequences for non-disclosure. The reason being is one should really assess that if any advantage has been derived from the fact that he's not disclosed the fact that he's funded. I mean, the idea of a disclosure is what? I mean, the way I look at it is the arbitrator needs to see whether he's conflicted. There could be another theory that there needs to be an assessment to see if the party who's funded, whether there should be some kind of security of cost that needs to be covered by him. Now, these are the two things. Having said that, again, just because a party has sought to be funded doesn't necessarily mean that he is in a position that an order of cost should be, an order securing costs should come against him. Maybe the standards of an attachment for judgment or our own MCIA rules, Rule 21 or I think 39 also speaks of costs. Maybe those standards needs to be met. Again, coming back to the question, like I said, I don't have an answer. In terms of an example, what if a party has been funded, he is not disclosed, and there's been an order against him? So I don't see what has happened in such a scenario. He has not benefited, that there's an order against him. But that said, if a party has been funded, he has not disclosed, and there's an order in his favor, then I don't know what the consequences are. This needs possibly to see on a case-to-case basis. It sounds harsh, but maybe setting aside of an award, that's something that maybe we'll have to consider.
Thanks, Ranjit. We looked at one of the things that has to be disclosed is whether the funder has undertaken to bear any adverse costs liability. And so, Christoph, I'm going to ask you a question on another rule, but that flows perhaps from here, and that is Rule 21 on security for costs. This is a new rule that's been inserted, but it is a power that the tribunal already enjoys, both under our Arbitration Act and also existing Rule 39E. So do you think this provision is necessary? Does it amplify the existing power? Was it required? And how does this provision compare with your experience with other arbitral rules?
I do appreciate that provision very much because I can tell you why. I'm currently in a situation in offshore arbitration under the German rules, and my colleague from Germany, please don't tell the German Institute of Arbitration that I'm going to say this here. Where we heard in the market that the opposing party has troubles, financial troubles, and we are not sure what to do now because the German arbitration rules do neither, that there's no section in there requiring disclosure of a third-party funding, which is, I think, combined to Rule 21. Because if you know that there's a funder, you can be sure that that there's financial security. So, but what the German rules also do not provide is a security for cost provision. So we now have to come up with some sort of application, and so I appreciate the security for costs section very much. What is important, what is not in there yet, is also to maybe give the tribunal an idea of what it can do. Shall it, render procedural order or maybe a partial award? But in my opinion, it has to be something which is enforceable. So I think an award would be the way to go. But yeah, I do appreciate that section very much.
Thanks. Andy, Rule 37 and Rule 21. How does the fact that a party is funded interact with Rule 21 and security for costs?
Well, I think this is a really interesting question. I think it's obviously very sensible to require the disclosure of the presence of a funder, and also whether the funder is undertaking to bear an adverse costs liability in case the funded party loses and costs are awarded against it. And I was interesting, Fatema mentioned the Tomorrow sales case. I mean, in that case, the division bench mentioned the fact that funding and the terms on which funding is given could well be relevant to security of costs. And I think they were right to do so. I mean, interesting you said that it's now being appealed to the Supreme Court, because I read the judgment and thought it was absolutely unimpeachable. I thought it was absolutely bang on and not really any basis for anyone to disagree with it. But coming back to the rules, and in particular this point about how could the funder undertake to bear an adverse cost liability, because I think that would be the next question that if you're the respondent to the claim, you might be asking, having learned that there's a funder involved and that they are or are not undertaking to bear that cost liability. So one possibility is that there's a contractual liability from the funder to the funded party for its adverse costs risk. Secondly, the funder might be willing to provide a direct contractual undertaking, perhaps by way of a deed, to the opposing party to say, if costs are awarded against the party who I'm funding, the claimant, we agree that we will pay the respondent those costs. That could be a possibility, and I know some funders are willing to do that. And the third possibility, which goes somewhat further, and I'd be interested to hear Indian lawyers' views as to whether or not this would work under Indian law, but again, this is something that I've heard some funders indicate that they are prepared to do, and that is to actually give a submission whereby the funder agrees to submit to the jurisdiction of the tribunal, and I think this would probably have to be in the form of essentially a deed of adherence to the arbitration agreement in order to become party to the arbitration agreement, party to the arbitration, subject to the tribunal's jurisdiction, and therefore a costs order could be made directly against the funder itself, which would then put it in a different position from the funder in the Tomorrow sales case. And so those are things I think don't need to be in the rules, but those are things that tribunals, opposing parties could ask about. Tribunals could take into account in deciding whether to exercise their jurisdiction to order security for costs. I mean, it seems to me that there's a few things that come out of security for costs, and the first one is that some arbitrators are very reluctant to order it and think it's something alien in arbitration. I disagree, and I think it's sensible to have it in the rules. Second thing is, it's usually ordered where the claimant is impecunious, but the tribunal has to take into account a balance between fairness to the respondent, who might succeed and then not be able to recover costs, versus the potential to stifle the claimant's claim if it's bringing that claim. And so the fact as to whether or not you have a funder, whether that be a professional funder or some other third party, could be a shareholder, could be a promoter, could be an affiliate, funding that claim on behalf of the impecunious party, those I think are relevant factors for the tribunal to take into account when deciding on the facts of that case whether it's sensible to order security for costs. And so having 37(1)(c), the obligation where a funder is involved to disclose the position as to whether or not the funder is going to bear an adverse costs liability, opens up the ability for opposing parties to ask these questions and then, depending on the answers, to make an application for security for costs.
Thanks, Andy. It always warms the cockles of my heart when someone says an Indian court decision was bang on. Okay, we're going to roll back up the rules to Rule 16, and I am going to ask Vikram on early dismissal and summary procedure. That's another new provision which already finds its place in some other arbitral institutional rules, and also potentially in one of the proposed revisions to the English Arbitration Act. Have you ever seen these provisions used of early dismissal or summary procedure? And do you think they're a worthwhile inclusion?
It certainly is a welcome measure and a huge step forward, because one of the criticisms today against arbitration, at least in India, is that it is as time consuming and as not cost effective as it should be. And therefore, I think this is a welcome provision. It remains to be seen how many make use of this provision, and it also remains to be seen how the tribunals proactively respond to such applications for early termination or disposal. As the title suggests, it's a summary procedure. So it really fits into with our legal framework, which is section 19, that the tribunal is the ultimate master of the procedure and how it governs or controls the arbitration. And I think matters where you don't need oral evidence, or it can be a documents only arbitration, or if you can call out an admission and something similar to your section 31(6) of the Arbitration Act. So this sort of gives us, the parties or the tribunal, further wings to take those provisions forward, like section 31(6). And if you can make out a case of an admitted liability, and that, or the defense is the moonshine defense, which is a popular expression used in India, you could probably end the arbitration early. And I think I see a lot of merit in it. And I think the MCI must be commended for putting this on the basis of other global best practices.
Thanks. Christoph, how do you view this provision in comparison to other institutional rules?
Well, compared to the ICC or the DIS, the German Institute, we don't have that. We don't have a similar. No, we don't have it. I think it's a common law thing. At least in civil law, we do not have a summary judgment. I do appreciate it because I think it's a matter of efficiency, and if you can apply for it, and to be frank, we have even internationally, arbitration is not always the quickest and most efficient way to resolve disputes. So I think it's a good idea, and it's in my opinion, all of the changes kind of try to make the arbitrations more efficient, more flexible, and with a particular emphasis on ending the arbitrations as efficient as possible. And I think that's a good approach. I hope that it will play out as planned.
Thank you, Christoph. That was actually a perfect ending to our panel. And I could stop right there, but I see we have a little time. So I'm going to ask each of you to give me a 30-second quick soundbite and tell me whether you have any other observations, good, bad. Avoid the bad, tell us the good ones, or any other comparisons or highlights to these rules. I'll start maybe with Andy.
Sure. Well, I think just a general comment is, reading through the consultation draft, it seemed to me that these are essentially, you have already a good set of rules, and these are good incremental changes, as Christoph says, that are going to increase the efficiency and the procedural tools available. I think one specific point I might just mention, just because it's interesting, is the expedited procedure rule, which is Rule 17. So the existing being under the monetary threshold, all the parties have agreed to the expedited procedure. There's a slight increase in the monetary threshold, but that's really non-controversial altogether. Wording actually mirrors what's in the current SIAC rules. Now the SIAC are considering amending their rules and changing it to say circumstances warrant the application of the expedited procedure, and it's interesting that the MCIA has chosen not to follow what the SIAC is proposing, and I think they're absolutely right not to do so, because I think that circumstances warrant language is so vague it's almost impossible to advise on. So I think the MCIA's proposal is very sensible on that one.
Christoph?
I think I rounded up my my impression of the rules and changes, so I'll give it over to you.
So Shaneen, what I find really interesting is how these rules are really tied up together. Like third-party funding is tied up with security for cost. Concurrent and consolidation is, although concurrent is now introduced, it kind of gives that distinction of what should be chosen and when and how it goes hand in hand. Similarly, expedited and emergency arbitration, early dismissal or expedited procedures, how the two have been introduced for different scenarios. So I really like how the rules are trying to tie in the different concepts to work hand in hand. So that's my take on it.
I think despite my being part of the council, I would still go ahead after my disclosure that I must compliment the entire governing council with super value additions by global experts on arbitration. So Nish, Vyapak, and all others on the council persevering, actions of the Madhukeshwar, Niti. Ultimately, I think all the global best practices have been, at least a sincere attempt has been made. Shaneen, you have been part of that team to bring them into the MCIA rules. I think change is the only constant, and I think we will continue to be encouraged by that.
I don't think I have anything to add. Just one thing, Andrew mentioned that proposed rule, where the tribunal has to consider a consolidation. Andrew, with the additional point where he can consider the questions of facts and law. I think, unless I'm mistaken, you mentioned that it's not something very important, but there is an additional factor. In fact, I would think that he's in a better position, given the fact, he's seized of the matter. He's in a better position to understand whether the question of facts and law are similar. And if I'm not wrong, I think SIAC in its consultation has considered this, but I think in the new amendment, I think even SIAC should have it.
Yeah, I think you're right that the SIOC are considering adding it in. And I think my point on how important it, I think it's sensible to add it in. I think it's a useful point. I think in most cases, you will probably also satisfy one of the other grounds, a series of transactions, etc. But it seems to me it's useful to have it in as a factor that the tribunal can take into account.
Okay, now you're probably thinking that I'm going to open it up to audience questions, but I am not. Because the rules are open for public consultation, and I would really like anyone who has a question or a suggestion to write in with your thoughts. Niti, where should they write in? Does everyone know?
It's on our LinkedIn and on our website. And there's a link to it. You can click, they can upload their comments. They can also just fill in the comments in.
So please do that. Okay, no questions. And we look forward to the next keynote address. Thank you very much. Thank you all.
Thank you.
I request you all to please remain seated. We'll be commencing the keynote address very soon. A very good evening to everyone. I would like to invite on stage Mr. Milind Sathe, MCI Council Member and Senior Advocate, to introduce the judge.
Good evening, ladies and gentlemen. I have the privilege of introducing this evening my friend Somasekhar. I could have said that Justice Somasekhar Sundaresan needs no introduction to this crowd, and I could have and should have sat down. But we belong to the profession and vocation where, after saying, needless to say, we write reams and reams of paper, so I will follow the precedent and say something more. Justice Somasekhar Sundaresan is known in legal profession and now as a judge as domain expert. But that is not correct. Because he has, in a short span, after becoming judge in November 2023, has proved that he is not only a domain expert in respect of the laws relating to securities, SEBI, markets, etc., he has virtually mastered and has become a proficient expert on variety of subjects which he has dealt with as a judge in this last span of about 10 or 11 months. He is an alumni of R.A. Poddar College of Commerce and Economics, and then alumni of Government Law College in 1996. During that time, while he was pursuing his law, he joined the Times of India as assistant editor of business section of Times of India, and he combined his skills of legal knowledge, writing with journalism, and he excelled in that tremendously because virtually he was reckoned during those times as a successful business journalist. After that, of course, he took plunge into legal profession, and under the guidance of Burgess Desai of Udwadia Udeshi and Company, till that firm rearranged and he joined J. Sagar and Associates, eventually to become the partner heading the capital market section till 2016 when he started his own practice. During that period, from 1996 till 2016 when he was practicing law, he has excelled himself in the securities laws and all related fields relating to SEBI's competition laws, markets, etc. As a practitioner, he not only practiced in High Court at Bombay and Supreme Court and of course other high courts and various tribunals, he also was part of variety of legislative committees formed by Government of India, SEBI, Reserve Bank of India, and during that tenure, he has been part and parcel of various committees for either framing, amending, or drafting regulations relating to takeover, insider trading, and variety of subjects. I cannot enumerate them. The evening will not be sufficient to enumerate and elaborate his work in that field. Thereafter, he continued his practice in Supreme Court and High Court side by side, and he has been a part, he has argued successfully in Supreme Court series of matters. In High Court, he has argued series of matters, and of course, a last assignment as a lawyer he took was, everybody knows about it, the Supreme Court had appointed a 6-member committee to inquire into the irregularities, if any, in the stock markets because of certain reports. And he was a part of that committee. That was his last private assignment. And after that, he has been a judge of Bombay High Court from November 2023. And we are very proud to have him as a judge of Bombay High Court. Though he has a very short span so far, 11 months, he has excelled, as I mentioned earlier, not only his domain, but in variety of subjects, because as a judge, you do not get a choice of subjects on which you need to work on, what cases you can hear, what judgments you get to write. That choice is curtailed, which you have as a professional. So he has not only authored judgments while sitting singly, most of the time he has spent with the senior judges, but while he sat singly, he has written large number of judgments on arbitration law under sections 11, under section 9, etc. On DB, on division benches, he has authored judgments not only on arbitration law, but I must say on variety of subjects ranging from the Land Revenue Code, the Land Acquisition Act, the Urban Land Ceiling Act, Cooperative Societies Act, and of course whether you can purchase agriculture land or not under the Bombay Tenancy Act. So he has not practiced in those subjects, but the bar is very, very happy and regales about his expertise on all subjects. So if you are a domain expert in one branch, one subject, as a judge, you can certainly excel in all other fields, as he indeed has done. As a judge, of course, he can now, when he interprets the laws, some of which, or regulations, some of which he was part of drafting, he can proudly profess the legal principle of interpretation, that original intent theory. He can authoritatively say that that was the intent of the legislation because he was a part of the drafting of that legislation. He, apart from being a lawyer and now a judge, he is a keen trekker, and he has been to some unpronounceable places in Himalaya, and he has a dream of conquering Everest. I'm sure that dream he will one day fulfill and realize, but I am certain that before that, in the career which he has now undertaken, that is the judicial career, he will certainly conquer the Everest in the judicial field, and I wish him success for that and welcome him in our midst this evening. This is my first task I'm performing as a member of the Executive Council of MCIA. So I welcome him here in our midst this evening. Thank you.
Good evening, everyone. Can we do something about the lights, or? Okay. Okay, I was collecting my, good evening. It's a pleasure to be here in your midst. It seems to be raining arbitration sessions, many of which use this venue. So it's nice to be back and see so many familiar faces in the crowd. What I thought of speaking about today is pick a few thematic issues that we face. The fact that we're doing this brainstorming and meditation on what faces arbitration in India, I think it's important to introspect a little bit and think about what are the challenges that we face. Has arbitration as a dispute resolution mechanism worked? What ails its success? And what is it that we need to do as a community? We as a community, we are all lawyers first, judges later. As a legal fraternity, is there something we are not doing right? What is it that commands attention to us as a community which can resolve disputes in preference to expensive litigation in courts? expensive not only in terms of money, but also in terms of time. And in that context, I was going through the themes of your sessions, and I felt it'll be good to connect a few dots and see whether we could build a theme of what is going wrong, and think about what is a way to deal with it if we mean to be a credible avenue for dispute resolution. I, for one, perhaps because I'm a markets lawyer in my practice, I do feel markets find a way to value assets and services. Markets are good judges of whether a certain avenue is worth investing in. So we have to ask ourselves, do litigants, do practitioners, and by markets I don't really mean the practitioner market, but the markets that buy services from us practitioners, from lawyers, the clients, the litigants, because the litigation is actually of the client. We lawyers and judges and arbitrators are intermediaries between two competing, contesting litigants to try and get their disputes resolved. So when I was looking at the sports, the arbitration in sport as a theme, my thoughts went to why would it succeed when it is sport? I mean, you have an Olympic, we all now know in India, thanks to Ms. Fogart, that there is an arbitration when it comes to a dispute in sport. Why does it work? Of course, there were 2 extensions before that award was given out, but I need to ask a question. I mean, is it because there is no say in the party to choosing the arbitrator? When every Olympic athlete signs up to dispute resolution by that arbitral court, but there's no haranguing over who's the arbitrator, is that an objective person, I don't like his face, you don't like the one I suppose. Then we go through a mechanism to appoint an arbitrator. That process takes 3 years. Then an arbitrator is appointed. That is absent in that Olympic sport tribunal. Is it time to think about creating an institutional framework where party autonomy, great autonomy in terms of choice of the dispute resolution mechanism, but stopping short of actually identifying who the arbitrator should be? Let the institution deal with it. You don't get to choose which judge will adjudicate your matter. It's a roster. The Chief Justice assigns the roster. Whoever it comes before, it's a roulette. You come before a judge, the matter goes on. But if you say sign up to the MCIA or the ICC or any arbitral forum, should there be an allocation system that does not involve the parties exercising a choice is a question to ask. When I took oath, I gave up my right to free speech and expressing opinion outside the judgments. So I'm only going to place questions and see whether these are questions and these are points on which we need to introspect. So the sports session gave me that thought of whether to succeed in getting the first step of arbitration going, do we need to think of a mechanism where an institution picks the arbitrator, cutting out one round of disputes over who the arbitrator should be, leaving it to the institution to perform well. Now this again means that the institution, for the markets to believe in that institution, must carry a lot of credibility. And that credibility has to be built over time, the credibility of that institution in making the right choices of an appropriate arbitrator, of ensuring that conflicts of interest don't exist, of having mechanisms to deal with disclosures and the like, is something that one needs to think about. So that's a thought I thought I'll leave with you. The second question, the related question, is about for that institution to command respect from the market, we have to seriously think about, as an arbitration bar and as arbitrators, do we carry credibility where the markets choose us rather than the markets have to make do with what they have, what's on offer? Is the profession of being an arbitrator now a profession like the law profession or the chartered accountant profession or the actuaries or the architects? So many professions are regulated, and self-regulation is how professions are typically regulated. And the governments are stepping in. Like if you've seen what's happened to accountants, the ICAI now only makes standards. conduct of auditors, there's an NFRA which has stepped in. So the regulatory function or oversight of a professional's functioning, professionals will cede ground to the state if they don't effectively self-regulate. So how can arbitrators self-regulate? What is the forum? What should be the mechanism? What sort of a regulatory environment should arbitrators have to regulate conduct of arbitration, conduct by arbitrators when they conduct arbitration is also a theme I wanted to leave behind. These are all conceptual policy choices that will need to be made, but policy choices are made by legislatures when a society is ready enough to present a policy choice. We've seen recent amendments where there is a schedule of fees. The best that the legislator could understand was, all right, we need to regulate fees. It's very easy. You know, we in India have come with a legacy of 60, 70 years of price control and state control. So the first feature we've seen is to regulate the fee through the fourth schedule in the Arbitration Act. Would this suffice, or is it even appropriate? Is it a wrong medicine for a right ailment, or is this an area we need to think about? So what are the mechanisms that we as a profession of an arbitration bar and panels of arbitrators, how do we regulate ourselves in a manner that the markets are given assurance that the intensity of promise from the performance of arbitration as a dispute resolution mechanism is worth the markets investing in? I can tell you, I was also a transactional lawyer for a very long time. And over time, we found that corporates are abandoning arbitration, particularly in certain types of disputes. I mean, you may not be able to abandon arbitration for a shareholder dispute or a shareholders agreement, but where a pure summary suit would do the trick, why would a commercial entity choose arbitration and risk not having that option to strike at a summary suit without having to lead a trial? These are questions that we need to think about. Then I saw another theme about the controversial question about whether courts should be allowed to modify arbitration awards. And my thoughts go thus. I mean, if the minute you allow courts to modify awards, it's a horse which will run its own course. You may not be able to say on what terms and in what circumstances can courts modify awards. Can you say, bring a literal basic structure theory and say, without changing the underlying structure of the arbitral award, you may be able to modify? Only you may then correct errors. What is that error? What appeals to being a basic feature of an award to one may look like a very peripheral thing to another. And then the whole point about an arbitral award being a binary situation, presenting a take it all or leave it all situation, sounds very drastic, because at the end of an entire long litigation, the court may be left with no choice but to set aside the award, when what may ail the award may be a small portion of it. But the corollary to that is that in arbitration law, courts are not meant to disturb awards, even if there are errors. I mean, if there are the whole Section 34 regime, we're already seeing what's happening with matters of public policy, what about it being contrary to the fundamental policy of India, etc. So this is a slippery slope, perhaps, in terms of allowing an amendment to an award in the hands of a court, because it would then perhaps translate into a full-blown appeal. We can say that it's not an appeal, you can say it's only limited, but we're already seeing the effects of Section 34, and there are constitutional bench judgments that are coming out to deal with the scope of 34 and 37. So this is something that we need to think about. The binary position of take it all or leave it all is a very precious position, because again, inherent in it is the belief that market participants make their choices to go to arbitration. And if they made their choice to go to arbitration, they made their choice to opt for a less formalistic declaration of the mixed questions of fact and law involved in a dispute, and that should hold the field. Small errors here and there, or what notions of it being in conflict with legal principles, should not be allowed to come in the way and disturb the award. We also faced with situations where there's an award for specific performance of a supplemental contract which has got blanks in it, and parties, and there are arbitral awards saying, yes, now you perform, and then you come to court and you say, what is it that you want performed? And that litigation goes on for years and years. So it may be tempting to go down this path, but a note of caution would be that if we embrace the principle that awards can be modified by courts, we need to then embrace the principle that if not de jure, de facto, it may lead to a full appellate review of the awards. How much are markets prepared for that? How much are participants prepared for that is something that we need to think about. Then there was this theme about in-house counsels and the expectations from arbitration. And in some sense, what I've spoken already touches upon that. We need to ask ourselves, are we delivering value for our stakeholders? I mean, we are stakeholders, all right, but we are still intermediaries. The ultimate user of the law, the end user of consumer of justice is the litigant. Are we delivering value to the litigant in terms of arbitration as a forum is a question we really can't run away from. And if the answer to that is maybe, then we are in trouble. Because I think Justice Pitle, who was here this morning, spoke about the government notification of disputes above a certain threshold. Governments are saying, we'll take our chance with our civil courts. We don't need to go into arbitration. And commercial parties may take that view. And that's not a good sign at all, because we're then actually establishing a principle and a precedent that markets are perhaps reconciled to the fact that this forum is not working. And because this forum is not working, this is something we need to conceptually embrace, that effectively a good section of the market may choose not to opt for arbitration and to go to courts instead. So what lies ahead? I mean, how do we build credibility? How do we build a regulatory framework where parties feel comfort that opting for arbitration is going to be an effective dispute resolution forum for them is a very important question that needs to occupy the minds of the lawyers and the arbitrators very intensely. The arbitration bar can't be a weekend bar. It can't be that we'll do arbitration on Saturday and Sunday and do our court practice during the week. I don't want to name names, but all of Bombay, you speak of a specialist in arbitration, you get two names. These are the focused arbitrators in Bombay. Why then we also, as I don't know how many of us are purely Bombay and how many are straddling two worlds like many of us did in practice of Bombay and Delhi. We need to ask ourselves, why is Delhi stealing a march? Or if we have to first acknowledge that Delhi is perhaps stealing a march. Acknowledging the existence of a problem is the first part of the solution to the problem. It's a venue where you then get to do the arbitration, do all your Section 9, Section 34s, and appeals from that to the local High Court and appeals from that to the Supreme Court, which is in Delhi. That's a huge strategic advantage that center has over other centers like us. We are the commercial capital. So as a Bombay arbitration community, we need to rethink and reimagine what can we do to reclaim ground and maintain Bombay as a center of effective dispute resolution. I mean, we are a 4 trillion economy today. Forget the 5 trillion number and when it will come. But even today, we are a 4 trillion economy. And we are the third largest economy in the world in purchasing power terms for a few years now. Do we have a dispute resolution system which effectively is commensurate and proportionate to this standing that India as a community, as a market has in the world, is a question we need to ask ourselves. I'll conclude with, I didn't mean this to be a morose sort of theme, but I thought this is an opportunity to table thoughts that came to mind. Many of you will remember this phrase, ease of doing business. It's such a band-aid phrase that it's found its way even into the preamble of the Commercial Disputes Act in the statements of objects saying we need to improve our rankings in the ease of doing business survey. This was a survey conducted by the World Bank with various statistical tools and metrics thrown in to put an econometric model to features, and India improved significantly in many features, but it remained static in one chapter, enforcement of contracts. enforcement of law and contracts, we remained in the bottom 10 or 15 or 20, I don't remember the exact ranking now. Of course, these studies were being gamed because various economies merged 10 steps into one. If you had 10 forms to fill, they would make one form of 10 pages. And they said, oh, there's been reform, and these rankings were gamed. And many countries gamed it so well that the World Bank stopped this survey. It's not an effective survey anymore. But in there lies a message that we need to think about. Why would we lag so far behind in law enforcement? Individual symptoms don't present the problem. You can say we have very few judges, or we can say under-resourced judiciary, we can say overburdened judiciary with government as a litigant. There are many, many truths coexisting and colliding. But arbitration, let's remember, was meant to be an alternate dispute resolution mechanism where we don't need to burden the courts more with what we have. We need to be able to have an effective resolution on our own. Have we succeeded in that, or have we failed an opportunity to do good, to do well, and improve? Because people don't realize that a commercial dispute can finish a business. A small business, a medium-sized business, an MSME, if it has a 20 crore claim and it can't recover that 20 crores in a commercial dispute, chances are that enterprise may shut down. If that enterprise is shut down, the cost of reinitiating that enterprise is so huge that it has a significant impact on the economy on a larger scale. So we need to take these headwinds, we need to take these symptoms seriously and consider what is it that can be done as a community to improve the standard, to improve the quality of arbitration. Are our rules commensurate? I mean, I know that you all are discussing your draft rules just now, and that's up for grabs for discussion. How seriously does the community participate in rule making? Not many are aware that even subordinate law under parliament-made statute, there is a public consultation in almost every regulatory agency. How many people actually participate in that pre-legislative consulting to add value? We in fact have one Supreme Court judgment on the call drop system, where if a call dropped, the theory was if you penalize the telecom service provider for every call dropped, the problem would be solved. In the pre-legislative consulting, technically it was demonstrated that just putting a monetary penalty is not going to solve the call drop, because the problems for the call drop was something else. The regulator ignored that feedback and still implemented the law. The Supreme Court struck it down using this pre-legislative consulting as the empirical means of saying it's arbitrary and disproportionate, because available was evidence about the policy choice being totally a misfit to the problem sought to be solved. So likewise, when there is draft, whether it's draft rules of the MCIA or it's anything to do with even draft amendments to the Arbitration Act, how effectively does the community participate in these legislative exercises, in this consultation exercises, is also an area I want to leave behind for us to introspect on, because we get the laws we deserve. If we don't participate, if we think that nothing is going to happen, this law will never come up, like we did with Companies Act 2013. Everyone said, oh, this bill is never going to be passed into law. We are months away from the next election. And lo and behold, we had the Companies Act 2013, which was perhaps one legislation which sought to address everything that was found wrong in one case that went horribly wrong in the governance of a company. So these are again things to ponder over. How effective are we in all these areas? And if we participate in all of these, if we think about every time you take a decision to oppose the appointment of an arbitrator, every time you advise your clients to challenge an award, we ask ourselves, is there an externality that's being created by this? Are we also, for every effective delay in enforcement of an award, are we also sending a signal that no one ever comes to arbitration in future? We will then perceive the cost of the decisions we take as professionals on what advice we give clients. Because you may get that fee today, you may get that delay in enforcement today, but 2 years down the line, clients may actually say, you know what, we really don't want to arbitrate. And that catchment area is actually eroded with every such decisions. So I just wanted to leave you with these thoughts. I'm sorry if this has been a bit of a polemic or a very morose or a negative thing, but I thought it's a good way to end the day, having sat through all these sessions, to introspect on what can we do better in terms of the content of all these sessions that we've articulated through the day. Thank you very much for having me. It's always a pleasure to speak to all of you. Thank you.
Thank you, sir, for your insights. I would now like to invite Mr. Nish Shetty, a co-chair of the MCI Council, to give the vote of thanks.
Thank you very much. I was going to say that the theme of both my vote of thanks and my concluding remarks was going to be encapsulated in the phrase, "Look how far we have come." Now, after hearing Justice Sundaresan's comments, I'm still going to say, "Look how far we have come," but I will also address some of the points that Justice Sundaresan, you have very, very helpfully raised. So I think rather than apologizing for it being depressing or polemic, I think it is absolutely the thing that we should be doing in conferences of this nature. It is about thought leadership. It is about addressing the issues of the hour and seeing where we can go to from here. What are the changes that are the most pressing, and what are the changes that we need to focus on? So you raised a number of issues, and I'm not going to deal with each and every one of them, but I will just remind everyone of some of these. And in doing so, I will invite both the members of the judiciary and also members of the Indian arbitral community to perhaps reflect on some of this. The first issue that I thought I would focus on is your comment that institutional appointment of arbitrators is something that should perhaps happen. Now, again, this is something that does happen outside of India and happens quite routinely, quite regularly without the involvement of the courts. Now, that obviously will involve some change, but the point that I want to make is we're dealing in international arbitrations, we're dealing in domestic arbitrations. There is a great amount of precedent out there, and I would invite everyone to look at what happens outside of India while you're also looking at what happens within India. There are lessons that are unique to India, and I imagine that not everything that happens outside can be translated into India, but there is a lot that does happen outside of India that could perhaps be introduced here as well. Even within the current system, MCIA has been the beneficiary of referrals from the judiciary, both from the Supreme Court and other courts, where the MCIA has become the party that would otherwise appoint an arbitrator. So that perhaps is one solution. Judge, I know we didn't discuss this, but I'm very glad that you raised this issue of whether summary judgment, for example, which is available in court, is something that the arbitral community should perhaps be cognizant of, and whether that's a differentiating factor. Now, you'd be happy to note that as part of the rule changes that have been proposed, that is a concept that we are proposing to introduce into the arbitration world. Now, this is not novel in the international arbitration world. It has been introduced in the context of many other institutions around the world. And when I come to how far we have come, I'll deal with that in a bit more detail, but perhaps I just wanted to flag that to say that even within the arbitral world, that is a gap that has been filled through institutional arbitration and institutional rules. The third point that I thought I would focus on in my vote of thanks to the judge for raising these issues is really around modification of awards and your candid feedback that it's, to quote you, a slippery slope. I couldn't agree more. The whole idea of having an alternative dispute resolution process is that it's an alternative. And if parties have chosen that, barring very specific instances, the idea is not to have an appellate process through the court system. If parties have voluntarily chosen that and have consented to it, then really what the courts can, in my respectful submission, what the courts should really be doing is presenting a supportive role to what the parties have already chosen. And that's what the intent of the legislation is, and that's how it's again applied in many, many jurisdictions around the world that have virtually the same laws that India has. In terms of the answer trial model law, it is not that different. So perhaps that experience from overseas can also be considered when we're considering this issue. The final point is really around ease of doing business, and Judge, again, thank you for raising that, because in my view, we're going into, again, I'll use this phrase, a golden age for India. Again, I practice in Singapore and I'm looking almost from out in. I think the inflow of capital into India, in my view, will be unprecedented in the next decade or so. And Indian practitioners, Indian judiciary should really should celebrate that and should also facilitate that in whatever way it can. So finally, in terms of how far we have come, what I wanted to touch on was this. When we started MCIA in about 8 years ago, one of the things that Madhukeshwar and I were discussing was the need to have a conference, an arbitration conference. Because again, internationally, you could attend 2 arbitration conferences a day and you would not finish attending all of them. But in India, that was not quite a thing. And Madhukeshwar said, who's going to come? Who's going to leave their busy court practice and come for an arbitration conference? And also, I said, okay, we should also charge money for it. And he looked at me as if I was crazy. And he said, you're going to charge money, take them away from their high-paying practice in court and ask them to come for an arbitration. In 8 years, we've gone from having a half-day arbitration event to a week-long event across 3 cities. And that to a sold-out event weeks in advance, where you're having distinguished members of the judiciary and other practitioners sharing thoughts and discussing what more we can do to improve the arbitration landscape. So I think we have come a long way. So and we shouldn't forget that while we're considering what are the challenges, we shouldn't forget how far we have come. The transcription that you see is an example of this as well. The first time we introduced live notes, and something that Madhukeshwar and I discussed at the time, and said, we want to show how live transcription takes place. And at the time, we had an international service provider come and translate the conference as it was going on. And people were coming up to us and saying, is everybody reading from a script? How is it that everything that is being said is coming up on that screen right there? Again, fast forward 8 years. What you're seeing on the screen is not an international service provider. It's an Indian service provider doing it, Terrace. So again, how far have we come? I think it's something to celebrate. And I'm told that Terrace is now transcribing in the Indian courts as well. So we have come a long way. The journey continues, but we have come a long way. The third is around really rules. And I touched on the fact that, and the judge as well, and others have touched on the fact that we are hoping to amend the rules. And we are going to amend the rules. And the draft rules have come up for consultation. Again, in response, Judge, yesterday marked the day when those rules have been disclosed to the public for consultation. Even the first set of rules that we introduced, we consulted the bar, we consulted members of the judiciary, we had Indian practitioners, we had international practitioners that came up with the first set of rules. It's lasted us 8 years. And at the point in time when we introduced those rules, some of what we are introducing now was already in play in the international context. But it was a deliberate decision not to introduce it in the first round of the rules, because the feedback that we got from very senior members of the Indian community, legal community, was the market is not ready for it just yet. So let's have the institution build credibility. Let the rules as they are come out. Let us work through that. We'll see what issues crop up. But today, The same Indian practitioners and other Indian practitioners, together with the international practitioners, have come to the conclusion that what you're seeing now in the draft rules is best in class in the world. Now, when the draft rules were being talked about, for me, it was a moment of pride when a senior German practitioner is here saying, I wish we had this in Germany. Right? Many of us hold German standards as being among the highest standards in the world for very many things, but I think we can take pride in some of these things. The fact that the community has reached a point where we can be best in class, and we may well be setting the standards for others to come. And that's what MCIA aims to do. Two final points. One is referrals. I touched briefly on that. Again, from the judiciary, we've been fortunate to get those referrals from the judiciary. One of the messages I'd like to leave, or thoughts I'd like to leave behind, is for practitioners who are appearing before the courts in India on these motions for appointment of arbitrators. Why don't you make that request of the judiciary, that this be done by an institution rather than the judiciary itself? Make that as a request, and hopefully, if the judge in question feels it's appropriate, we'll make that order and we'll simplify that intervening process that Justice Sundaresan talked about. Final point, really sort of way forward. MCIA in the last 8 years has done a number of things. One is it's increased its caseload, it's increased its visibility, but it's also built a lot of capacity on the ground in India. And I can see that as being part of that journey moving forward as well. If you look at the MCIA report, the annual report, you will see that nearly half of the arbitrators appointed are women. You have counsel that are appointed, you have international counsel that are appointed, in addition to the Indian judges that are appointed to these arbitrations. So I think building capacity, ensuring diversity in appointments, and ensuring timeliness, that's been the core of every message that we've delivered through MCIA over the years, and that I think will remain the core of MCIA's sort of ethos. So do have a look at that report. In terms of dispute resolution more broadly, I think MCIA just aims to be the gold standard in India, and perhaps it'll be the gold standard in the region as well. So those are my concluding remarks. I think we're all grateful to all of you for attending this event, and I hope you've had a fruitful day of discussions and deliberations. And what stands in the way now of me concluding this and drinks is virtually nothing. So let's all conclude this evening with some drinks and enjoy the networking thereafter. Thank you very much.
Thank you, Mr. Shetty. And with that, we conclude for the day. And I request you all to please join us for drinks and dinner. Thank you. And we request you to join us tomorrow as well at 8:30 for the breakfast event. Thank you.